Good morning, hello, and welcome. Whether you are a student curious about privacy law or a professional navigating data protection in your field, or simply someone who wants to understand GDPR in a clear and simple way, this video is for you. In today's digital world, data is power and privacy is a right. That's where the General Data Protection Regulation or GDPR comes in. But understanding GDPR doesn't have to be complicated, and that's exactly what I aim to do in this video. Together, we'll walk through the origins and evolution of GDPR, uncover its scope and applicability, and explore its core principles like lawfulness, fairness, transparency, and purpose limitation. We will then dig into the legal basis for processing data and how organizations must earn the right to use personal information. You'll also learn about the 8 powerful rights granted to the data subject, from accessing their data to the right to be forgotten, and the obligations organizations must fulfill to stay compliant. I will also try to break down how enforcement works, what the penalties look like, and what this means for different industries like the tech, healthcare, education, and finance. But that's not all. We'll also zoom out and examine how GDPR fits into the larger world of data governance, how it has influenced global privacy laws, and the technological tools organizations use to stay compliant. We'll explore the ongoing debate of innovation versus regulation, look at the challenges and criticism GDPR faces today, and close with thoughts on the future of GDPR and data protection in an increasingly connected world. My goal in this video is simple: to make GDPR understandable, relatable, and relevant. Whether you're just starting out or you have been in the privacy and compliance space for years, we will go through as many aspects as possible so that the understanding is clearer and any fog on this subject can be taken off. So grab a cup of coffee, get comfortable, and let's explore GDPR simplified and demystified. Do not forget to like, share, and subscribe only if this has helped you in any form and shape. Leave a comment if you would like to explore other compliance tools like DORA, DPDP Act, NIST, AI regulations in future video. While do note, some of them have already been covered in my earlier videos, some are on the way. So keep a close watch on the channel. This is your host, Savit Vittal Salian. Namaskaram. And thanks for watching. So let's dive in. Welcome to part 2 of the General Data Protection Regulation. In part 1, we covered the introduction, origins, and evolution of GDPR. We looked at scope and its applicability. Then we looked at the core principles of GDPR. We did look at the checklist. This, to remember, that's an indicative checklist. You can use that as a base reference. You can build on it, refine it according to your business, your line of trade. You can look at the regulators that you have to engage with. And if GDPR requires you to be in compliance, you can use that as a base reference. Do note it is a base reference. Do make an effort to refine, enhance it so that it fits to your needs and it's fit for purpose. In this part 2, we will look at other aspects as we move forward. I'll try to provide checklist for as many streams as possible so that helps you understand it. Let's look at the legal basis for processing data. GDPR outlines 6 lawful bases for processing personal data. The first is consent, which is explicit permission from the data subject. Second, contractual necessities, that is processing needed to fulfill a contract. Legal obligations, that is as required by law. Vital interests, that is necessary to protect someone's life. Public task, carried out in public interest. Legitimate interest, which is pursued by the controller unless overridden by data subject rights. In simple language, under GDPR, you can't collect or use someone's personal data just because you want to. You must have a valid reason called a legal basis to do it. There are 6 legal bases you can choose from. You must pick the one that fits why and how you are using the data. Consent. You ask the person and they say yes. Example, a person signs up for a newsletter and clicks I agree to receive emails. That's consent. Next, contract. You need the data to fulfill a contract or agreement with that person. Example, someone buys a product online, you need their address to deliver it. That's contract. Legal obligation. It is you need the data to follow the law. Example, an employer keeps employee's salary record for tax reporting. That's legal obligation. Vital interest. You need the data to protect someone's life or safety. Example, a hospital accesses a patient data in an emergency to give urgent care. That is vital interest. Public task. You are doing something as part of your official public duties, like a government task. An example, a public school processes student data to meet education requirements. That's public task. Legitimate interest. You use the data for your business interest, but you must not harm the person's rights. Example, a company uses customer data to improve its services, but gives people a way to opt out. Now, why does it matter? Matters because you must choose one legal basis before processing the data, the personal data. It matters because you can't switch your legal basis later without a good reason. It matters because you must tell people which basis you are using, usually in your privacy policy. In summary, GDPR says you can only use personal data if you have a good legal reason, and you must be clear about what that reason is. Now just let me help you with a checklist, maybe that helps with the context. Use this checklist to determine whether you have a valid and appropriate legal reason for processing the personal data. Ask yourself, have you identified a legal basis before beginning the process? Have you clearly chosen one of the 6 legal bases for each data processing activity? Is the chosen basis appropriate for the purpose of the data in use? Is the legal basis documented and explained in your privacy notice? If the answer to all of this is yes, you are starting your data processing on a solid legal ground. So, are you using the correct legal basis? Let's match your activity to the appropriate basis. Let's look at consent. Are you asking people clearly and freely for permission? Can they say no or withdraw consent anytime? Is their choice recorded and respected? Use this when no other legal reason fits and individual agreement is needed. Do note, use this only when there are no other legal reasons fitting and in this case individual agreement is needed. That's consent. Contract. Is the data needed to deliver a product or services? Would the service fail without this data? Use this when you are performing a contract or taking steps at someone's request. So in the first, it is use this when no other legal reason fits. That's in consent. In contract, use this when you're performing a contract or taking steps at someone's request. These are critical to categorize on what is your legal basis, consent or contract. Next, legal obligations. Are you required by the law to collect or keep the data? Ask this question to yourself and to the organization. Can you name the specific law or regulation? Use this when compliance with the law is a reason for processing. So when you say it is required by the law, it's your duty to specify which law, which regulation, to an extent of which section, subsections. So that's very clear why you are asking. That's legal obligation. In the space of vital interest, you should ask the question, is the data needed to protect someone's life or health? Is that the case? Is it a life or death or emergency situation? Most of the streams other than the medical would not have this. Rare, but if that is the case, be clear, is it a fact that is this a life or death or emergency situation? Use this rarely, only for serious emergencies. Recommended for the controls team or the risk team is to see how many times this specific legal basis are used. If it is frequent, it's time to check, deep dive and figure out what is that emergency life and death situation that you are involved in that you need to invoke this part. Idea is it shouldn't be misused. Next, if it is about public task, ask the question, are you a public authority or performing a task in the public interest? Or is the task set out in law? Use this if you are part of a government or public service body. Hence, most of the private are out of this specific legal base. Having said that, if you as a risk manager, management team, controls team, audit team finds there are legal bases referencing this, it's time to investigate why, what is the basis of it. Is it a miscategory or a misuse? Correct it immediately if you find it. But these are red flags, vital interest and public task in private organizations. Even in public, this should be carefully been used. Hence, be conscious when you see these categories coming in. Legitimate interest. In this, you should ask, do you have a valid business reason for using the data? Have you done a legitimate interest assessment to make sure it doesn't override the person's right? Can the individual opt out if they disagree. Now, use this only when rights and freedom of the person are not harmed. Hence, once more, a big red flag if legitimate interest is popping up as a legal basis in GDPR. Time to investigate, double check, document that you have double checked it to come to a conclusion if you are in agreement. Next one is, have you informed individuals about the legal basis? Is the legal basis explained in your privacy policy? Do you explain why you are using their data and what legal ground? Are you providing explanation, and is the explanation clear and easy to understand, or is it a jargon? The onus is on you to articulate it into a simple language so anyone can read and understand. It is reasonable. If the answer is yes, you are being transparent as required under GDPR. In summary, the legal basis, if it is consent, the meaning is the person gave clear permission for their data to be used for a specific purpose. In real world, is a person agreeing to receive marketing mails by checking a consent box. Requirement and responsibility must be freely given, clear and easy to withdraw at any time. That's the responsibility of the organization. If the legal basis is contract, the meaning in this contract is the data is needed to carry out a contract with the person or to prepare for one. Real world example, an online store collecting your address to deliver your order. It's required. Organization responsibilities must to ensure that necessary for the contract and does not collect any extra data. When the legal basis is legal obligation, wherein the data is required to comply with the law. Real world example is an employer keeps employee tax record for reporting to the government. Organization responsibilities must point to a specific law requiring the data. If the legal basis is vital interest, the data is needed to protect someone's life or safety in an emergency. Real world example is the hospital case. Requirement and responsibility from the organization perspective is to use this only when it is absolutely necessary, and generally the conditions would be emergency. Recommended, define emergencies for your space. If the legal basis is public task, in this the data is used as part of official duties or public interest. A real world example is government agency processing data to issue ID cards. Organization responsibility must be legally authorized and in the public interest. Now, it is in the public interest. The onus is on the organization to define and articulate how it is of a public interest. If it is a legal basis is legitimate interest, the data is used for legitimate business reason that doesn't harm the person's right. Real world example in this case, a business uses customer feedback data to improve the services, ensuring it doesn't invade privacy. Organization responsibility must conduct a balancing test to ensure rights are not harmed and provide opt out options. Data subject rights. GDPR empowers individuals with enhanced control over their personal data. In simple language, it means under GDPR, a data subject is any person whose personal data is being collected or used. GDPR gives people strong rights over their own personal data. These rights help individuals understand, control, and protect how their data is used by organizations. Let's look at these controls. The first is right to be informed. Individuals have the right to know what personal data is being collected, why it is being used, who is using it, and for what purpose. The right to access, it means individual can request access to their data and information about this processing. In simple language, it means under the GDPR, the right to access is you have the right to know what personal data an organization has about you and how are they using it. What can you ask for? You can contact a company or organization and ask, what personal data do you have about me? Why are you using it? Where did you get it from? Who are you sharing it with? How long will you keep it? How can I correct or delete it? This is called as subject access request, and it's your legal right. Example, you signed up for an online shopping app and want to know what personal details, name, email, address they have. If they shared your data with any other company, you can ask for it. What marketing or tracking they are doing with your info. You can write to them and ask for this information, and they must respond usually within a month. Why this right matters? It helps you understand what's happening with your personal data. It gives you control. It allows you to check for mistakes or misuse. Do note, important, the request is free of charge in most of the cases. Company may ask to verify your identity before giving the data. If the request is too broad or complex, they might need extra time or clarification. In summary, right to access means you can ask any organization, what personal data do you have about me and what are you doing with it? Right to rectification. It's about individual can request correction to inaccuracy or incomplete data. In simple language, it means you have the right to ask a company or organization to fix your personal data if it's wrong or incomplete. What this mean to you? If your data is incorrect, that is wrong spelling to your name, or your data is outdated, that example old phone number, or incomplete, missing address details, etc., you can contact the organization and ask them to update it or correct it. Example, you notice that your bank has your name spelled incorrectly, or there is an outdated email address against you. You can send a request and say, please update my personal details. My correct name is so and so, and not one which has been currently recorded. How long do they have to respond? Organization must make the correction without unnecessary delay, usually within a month. If it is complex case, they may take a little longer, but they must inform you about it. Now, if they shared the wrong data, that is, your incorrect data was shared with someone else, then they must inform those third parties, correct the data within them too, and they are accountable for it. Hence, right to rectification means if my personal data is wrong, fix it. If it is missing something, complete it. And do the same with anyone you have shared that incorrect information. The next is right to erasure, that is, right to be forgotten. Individual can request deletion of the data under certain conditions. In simple language, means you can ask an organization to delete your personal data when it is no longer needed or you don't want them to keep it anymore. This is also known as right to be forgotten. You can have the right to erasure if the data is no longer needed for the reason it was collected. You take back your consent if the consent was legal, was the legal basis. You object to the data being used and there is no strong reason to keep it. The data was collected or used unlawfully, or the data must be erased to comply with legal obligation. The data was collected from a child through an online service. Example, you signed up for a newsletter but no longer want it and want all your data removed. You can ask, please delete all my personal data related to my newsletter subscription. Now, can the organization say no? An organization may refuse to erase the data if they legally need to keep it. If it needed for public interest, legal claim, or freedom of expression. But do note, the organization needs to inform you why they are saying no with clear explanation and quoting law if there is a reference. How long do they have to respond? Usually they must act within 1 month. If they need more time, they must tell you why. In summary, right to erasure means if I no longer want you to keep my personal data and there is no good reason to keep it, delete it. The next is right to restrict processing. This is about data subject can request a halt on data processing in specific scenarios. In simple language, it means you can ask a company to stop using your personal data temporarily, but still allow them to keep it. Think of it like pressing the pause on how your data is used. When can you ask for to restrict processing? You can ask a company to pause using your data if you think the data is wrong and they are checking it. The data has been used unlawfully, but you don't want it to be deleted. The company doesn't need the data anymore, but you need it for legal reasons. You have objected to processing and the company is deciding whether to agree. Example, you notice that your phone number is incorrect in a company's system. While they check and fix it, you can ask them not to use your data in the meantime. You can say, please stop using my data until the issue is resolved. What happens during restriction? They must store your data safely. They can't use, share, or change the data unless you give them the permission. It is for a legal claim. It is to protect someone else's rights. How long does it last? The restriction lasts until the issue is resolved. You agree to end the pause, or a legal reason allows processing to resume. In summary, right to restrict processing means you can keep my data for now, but do not use it until we sort things out. The next is right to data portability. Individuals can receive their data in a structured, machine readable format and transfer it to another controller. In simple language, it means you have the right to keep a copy of your personal data in a format that is easy to use and take it somewhere else. It allows you to move your data from one company to another without hassle. What this right lets you do? You can get your data in a structured, commonly used format like CSV or JSON, download it and keep it, send it to another service provider. These are the options that you can do with this right. Example, you are using one music streaming app and want to switch to another. You can ask the first app to send your playlist, song history, user setting. So you can easily transfer that to the new app. That's data portability. When does this right apply? The data was given directly by you. Data has been processed and based on your consent or a contract, and the processing is done automatically. When does it not applicable? Well, it doesn't apply to data collected indirectly like company notes or analytics. It doesn't apply if the data processing is based on legal obligations or public tasks. How long do they have to respond? Organizations must respond to your request within 1 month. Hence, in summary, right to data portability means let me take my data with me or send it to someone else in a format I can use. Next is right to object. Its individuals can object to data processing based on legitimate interest, public task, or direct marketing. In simple language, the right to object means you can say no to a company using your personal data in certain situations, and they may have to stop. It gives you the power to stop or prevent your data from being used in ways you don't agree with. When can you use the right to object? You can in case of situations like marketing. You can always object to your data being used for direct marketing like emails, phone call, or targeted ads. Example, you get unwanted promotional emails. You can say, stop using my data for marketing, and the company must stop immediately. That's under the marketing space. Legitimate interest, if the company is using your data for its own legitimate business interest, you can object if it affects your privacy. You feel your rights are more important than their business reason. Example, company using your data for customer profiling. You can object. Next is public interest or official authority. You can object if your data is used for public task or government related work unless they have a very strong reason to continue. Now, when your objections might be rejected, a company can refuse to stop using your data only if they have a strong legal reasons. The data is needed for legal claim or public duty. Having said that, they would need to explain the legal reason. They would have to explain the legal claim and what public duty are they referring to, the reason for which they are rejecting your objection. Now, how to use this right? You can send a simple written request saying you object to how your data has been used. The company must respond within 1 month. In summary, right to object means you are using my data in a way I don't agree with. Hence, stop it unless you have a strong legal reason not to. And do note, the organization has to explain if they are not processing your request or they are quoting something, then you have to have what is that they are referring to in written. Next is rights related to automated decision making. Individuals are protected against decision made solely by automated processes, including profiling. In simple language, it means you have the right to say no to important decision made only by computers with no humans involved. It also gives you protection against profiling, where companies use your data to guess things about you, like your behavior, interest, or credit risk. What is automated decision making? It's when a computer or a system collects and analyzes your data, makes a decision about you automatically without any human review. Example, you apply for a loan online. A computer system checks your credit score. It automatically approves or rejects your application, and there is no human involved. Why does this matter? Automated decisions can affect your job, credits, insurance, or legal rights. Make mistake or unfair judgment without understanding your full situation. You can say, I don't want this decision made only by a computer. I want a real person to review it. Your rights include the right to know when a decision is being made automatically, the right to ask for human to get involved, the right to challenge or explain the decision, the right to object to profiling in certain cases like targeted advertising. When does it not apply? Well, automated decisions are allowed if you gave clear consent. It's necessary for a contract and it's allowed by a law. Example, fraud detection. But even then, you still have the right to ask for an explanation and a human review. In summary, rights related to automated decision making means don't let a computer make big decisions about me without a person checking it first. Next is right to be informed. We discussed this earlier. You have the right to know. Now, what it also means is the company must give you clear privacy notice when collecting your data. So, that's the data subject rights. In summary, right to be informed. It means you have right to know what data is collected, why and how it will be used. You can use it when your data is collected directly or indirectly. The organization responsibility is to provide clear, easy to understand privacy notice before or at the time of data collection. The right to access. You can ask to see what personal data a company holds about you and how it's been used. You can use it anytime you want to understand or verify what data has been processed. The organization need to respond within 1 month, provide a free copy of your data and related information. Right to reset rectification. What it means is you can request for to fix incorrect or incomplete data. You can use it when you find that your personal data is wrong or outdated. The organization's responsibility is to correct the data without delay and notify third parties if it had shared. Right to erasure or right to forgotten, to be forgotten. What it means is you can ask for your data to be deleted when it's no longer needed or you withdraw your consent. You can use it when data is no longer needed or used unlawfully, or you want to withdraw your consent for any reason that you deem fit. From an organization perspective, its responsibility is to erase the data unless there is a legal reason to keep it. Under the right to restrict processing, it means you can ask a company to pause using your data but not delete it. You can use it if a data is incorrect, being used unlawfully, or during an objection review. Organization need to temporarily suspend processing while keeping the data stored securely. The right to data probability. It means you can ask portability, sorry. You can ask for your data in a portable format and transfer it to another service. You can use it when processing is based on consent or contract and done by automated means. The organization's responsibility is to provide data in a structured, machine readable format. The right to object. It means you can say no to certain use of your data like marketing or profiling. You can use it when processing is based on legitimate interest, public task, or marketing. The organization responsibility is to stop processing unless there's a strong legal reason or it's for marketing must stop. Rights related to automated decision making and profiling. You can object to decisions made only by computers and ask for a human review. You can use it if a decision has significant effect on you. The organization responsibility is to provide information, offer a human review, and explain the logic used in their decisions. Let's now look at organizational obligations. Starting off with Data Protection Officer or DPO. Organizations engaged in large scale monitoring or processing special categories of data must appoint a DPO. Now, what is a DPO? A DPO is a person who helps an organization follow data protection rules, especially the ones in the GDPR. They act as privacy experts and watchdogs, making sure the company uses personal data lawfully and safely. They respect people's privacy rights. They are there to follow GDPR rules and report problems like data breaches if needed. When is a DPO required? Under GDPR, having a DPO is mandatory if your organization is a public authority like government office or monitors people regularly and on a large scale, example tracking behavior online, or handles sensitive data like health record or criminal history on a large scale. Even if not required, many companies choose to appoint a DPO to show that they take privacy seriously. What does a DPO do? A DPO's main tasks include advising the company on GDPR compliance, monitoring data protection policies and practices, training staff about privacy and security, helping with risk assessment called as DPIA, which is Data Protection Impact Assessment, communicating with Data Protection Authority, which is primarily the regulator, helping people exercise their privacy rights, example access or delete their data. What a DPA should be independent. They shouldn't be told how to do their job. Well informed, they should know GDPR rule very well. Available, they should be easy for both staff and public to contact. In summary, a DPO is like a privacy guardian for your data. They make sure organizations play by the rules and protect your personal information properly. The next aspect of organization obligation is DPIA, which is Data Protection Impact Assessment. It's required for processing activities that pose high risk to individual rights and freedoms. In simple language, DPIA is a tool that helps organizations find and fix privacy risk before they start a new project or systems that uses personal data. It's like doing a privacy checkup to make sure the data is handled safely and lawfully. When is a DPIA required? A DPIA is required before starting a project that is likely to have high risk to people's privacy, especially if it involves large scale data processing, tracking people's behavior like online profiling or location tracking, using sensitive data like health, race, religion or biometrics, or involved in automated decision making such as credit scoring or job filtering. Example, launching a new app that collects user health and location data. What does a DPIA do? A DPIA helps an organization to describe what personal data has been used and why, identify potential risks to people's privacy, find ways to reduce or avoid those risks, decide if the project can move forward and under what conditions. What's in a DPIA? A good DPIA will include what the project is about, what personal data is used, why and how the data will be used, who can process it, what could go wrong, the risk aspect, how those risks will be reduced or managed. Now, who's responsible? The organization doing the processing must carry out DPIA. The DPO, if there is one, should advise and review it. What if a DPI shows high risk and it can't be reduced? The organization must contact in such situation with the Data Protection Authority, namely the regulator, before starting the project. In summary, a DPIA is like a privacy safety check. It helps an organization spot and fix risk to people's personal data before they start using it. The next is ROPA, which is record of processing activities. Organization in this must maintain detailed record of data processing operations. In simple terms, a ROPA is a written list that organization must keep showing what personal data they collect, use, share and store and why they do it. It's like a logbook which helps keep track of all the ways a company handles people's personal information. So why is ROPA important? Well, it helps organization stay organized and transparent. It helps prove compliance with GDPR if there's an audit. It shows they are taking privacy seriously. Now, who need to keep a ROPA? Most organizations that have 250 or more employees or processes data that are not occasional or involves special category like health, religion or handles data that could risk people's rights and freedom. Even a small company may need a ROPA if they process sensitive or large amount of personal data. So, what should be in a ROPA? Well, for a data controller, the one who decides how and why the data is used, the ROPA should include the name and contact info of your company and a data protection officer if any. What type of personal data are you collecting? The purpose of the data that you are using, who you share the data with, like the service provider, if the data is sent outside the EU, how long you keep the data, a general description of security measures to protect that data. For data processor, that is those who handle data on behalf of someone else, the ROPA is similar but focuses on what they do with the data. In summary, a ROPA is a simple but important record of how a company uses personal data. It helps organization keep track of data use and show they are GDPR compliant. The next is data breach notification. Well, breaches must be reported to supervisory authorities within 72 hours and when necessary to affected individuals. In simple language, a data breach happens when a personal data is lost, stolen, leaked or accessed by someone who shouldn't see it. Under GDPR, if a breach happens, companies must notify the right people quickly. This is called a data breach notification. Now, who must be notified? The first is the Data Protection Authority. They must be told about the breach within 72 hours. That is about 3 days of finding out. Even if you don't have all the details yet, you must still report it. You need to notify the affected individuals. If the breach is serious and could harm people like identity theft or fraud, the company must inform the people affected in clear and simple language. Now, what should be included in the notification to the authority? Well, you have to define what happened, what was the type of breach, how many people were affected potentially, possible consequences of that breach, what steps were taken to fix it. You need to have the contact details of the DPO or responsible person. Now that is for the authorities. To an individual, you need to inform the notification, what happened and when, what data was affected, how it might impact them, what they can do to protect themselves, how the organization is responding. Now, why does it matter? Well, it helps people take action to protect themselves. It shows the company is being honest and responsible. Not reporting a breach can lead to fines and penalties. In summary, a data breach notification means if a personal data gets into wrong hands, you need to tell the regulator and the people affected quickly and clearly. Now, coming on to privacy by design and default. Data protection must be embedded in the system and practiced from the outset. In simple language, it means privacy by design and privacy by default are two important ideas in GDPR. That means think about privacy from the beginning and not after the system or product is built. Organization must build privacy and data protection into everything that they do right from the start. Now, privacy by design, what does it mean? Privacy by design means you must plan for data protection while designing systems, apps, website or business processes. Don't treat privacy like an afterthought. It should be a core part of your project. Example, you are building a new app. You include strong data security, minimal data collection, easy to understand privacy statement or settings from day one. What is privacy by default? Privacy by default means the system should be set to protect privacy automatically without the user having to change the setting. Only the minimum necessary data should be collected and used. Example, when someone signs up for your service, only basic information is collected by default and they are not auto enrolled into marketing emails unless they say yes. What organization must do in this case? Design systems and processes with data protection built in. Collect and use only the data that really is needed. Set up a strong privacy setting as the default. Give user control over that data. Use security measures like encryption, access control, and data minimization. In summary, privacy by design is building privacy into the system from the start. Privacy by default means making privacy the standard setting. It's about protecting personal data automatically, not just offering it as an option. Let's now look at a summary. The obligation area, lawful data processing. What GDPR requires? Process personal data only on lawful basis. Consent, contract, legal obligations. It applies to all organizations handling personal data. Second obligation, transparency and information. What GDPR requires? Informing individuals clearly about how their data is collected, used and stored. It applies to all organizations collecting personal data. Obligation 3, third, data subject rights. It's about enable users to access, correct, delete or restrict their personal data. It applies to organization that holds individual level data. Obligation 4th, data security. GDPR requires using appropriate technical and organizational measure to protect the data. It applies to all data controllers and processors. Obligation 5th, data breach notification. It's about notifying authorities within 72 hours of a breach and informing affected individual if needed. It applies to all organizations experiencing a personal data breach. Sixth, data protection officer. Appoint a protection officer if you process large scale or sensitive data or are a public authority. It applies to public bodies or data intensive businesses. ROPA. Keep updated records of data processing activity, including purpose, scope, data types. Applies to organization with 250 plus employees or risky processings. The DPIA. Conduct a DPIA before starting any high risk processing activities. Applies to organization launching high risk data projects. Next, data transferring outside of EU. What GDPR requires? It requires to ensure legal safeguard for transferring data to non-EU countries. Applies to organization transferring data internationally. Accountability and documentation. Now, what's this? This is to able to demonstrate compliance with GDPR through policy, records and action. Applies to all organizations subjected to GDPR. Next obligation area is training and awareness. It's about providing regular privacy training to staff and raise awareness about data protection. It applies to all staffs involved in data handling or decisions. Regulatory enforcement and penalties. Each EU member state has a data protection authority responsible for monitoring compliance and handling complaints. This is what supervisory authorities are. In simple language, supervisory authorities or SAs are official privacy watchdog in each European Union country. Their job is to make sure organizations follow GDPR and protect personal data. Each EU country has one main authority, also called as Data Protection Authority or DPA, to enforce data protection rules. What do they do? First, they monitor GDPR compliance, which is to check if businesses and public bodies are following the rules. Second, they handle complaints. It's about people can report if their data rights are violated. Example, spam, misuse, lack of consent, etc. Third, they investigate and audit. They can inspect companies and ask for proof of compliance. Fourth, give guidance. They help companies and public understand how GDPR works. Fifth, issue warnings and impose fines. That is, if a company breaks a rule, they can give a warning, order changes, or apply fines. In this, the fines are as steep as 4% of their global revenue, or in cases 20 million pounds or euros. What if a company works in multiple EU countries? Well, there is something called as one-stop shop. One lead supervisory authority takes the lead in coordinating between the countries. This helps simplify things for international companies that operate in several EU states. In summary, a supervisory authority is your country's data protection regulator. They enforce GDPR, help people protect their rights, and hold companies accountable. From a penalties perspective, GDPR allows for significant penalties, up to 10 million or 2% of the global turnover for less severe violation, or up to 20 million or 4% of the global turnover for severe violation. Do note, the higher the supervisory authority or control, the lower would be the penalty. That is, if you are following the GDPR guidelines as expected, your penalties would be lower if there is a non-compliance or nil. In simple language, under the GDPR, if an organization breaks a rule like misusing personal data, not protecting it, or ignoring people's rights, they can face serious penalties. These penalties are meant to make companies take data protection seriously. GDPR has two levels of fine depending on how serious the violation is. Level 1 is up to 10 million or 2% of the global turnover, whichever is higher. This applies to less serious issues like not keeping proper record of data processing, failing to notify about data breaches on time, not appointing a data protection officer when needed. Then we have level 2, which is up to 20 million euros as a penalty or 4% of global turnover, whichever is higher. This applies to more serious violations like breaking the basic principle of GDPR, that is, using data unfairly or unlawfully, ignoring people's data right, like not deleting data when asked, or sharing data without consent. There are other consequences beside fines. There are warnings and orders to stop processing data. The required changes to systems or processes can be directed. Temporary or permanent ban on using certain data, and damage to the reputation and customer trust. How is this fine decided? The supervisory authority looks at how serious the breach is, whether it was accidental or intentional, how many people were affected, what steps the company took to fix it, whether it's a repeat offense. In summary, penalties in GDPR are serious and can be very costly. If a company doesn't respect people's privacy and breaks rules, they can face fine up to 20 million euros or 4% of the global income. Now let's do a small comparison on this aspect on penalties. So if we compare it, let's look at GDPR. In GDPR, the enforcement authority, supervisory authority in each EU country would have a say. The penalty for minor violation is 2%, penalty for serious violation 4% of the global turnover. Enforcement style is strict for large companies and varies by country. Under CCPA CPRA, which is US based, the enforcement authority is California Attorney General and California Privacy Protection Agency. Penalty for minor violation is $2,500 per violation. Penalty for serious violation is $7,500 per violation. Enforcement style is enforcement increasing, focusing on transparency. In Brazil, there is LGPD. The authority is National Data Protection Authority. The penalty is 2% of revenue or 50 million local currency. Penalty for serious violation is 2% of revenue or same, it's 50 million. This could vary, need to check what is the latest on the website. It's very active, centralized with increasing activity across. GDPR is also very active, and of course the California laws also. So all these styles are active. The DPDP Act is from India. Its authority is Data Protection Board of India. It's about 200 crore rupees penalty for minor violation or 1% of the turnover. For serious penalty is 250 crore rupees or 2% of the turnover. It's a new system, but it's active and ever increasing in its scope. From China, we have PIPL. The enforcement authority is Cyberspace Administration of China. Penalty starts with warning, rectification orders, or lower fines. But when it is serious, it's 5% of annual revenue or suspension of the business itself. One of the strictest law currently in play. So that's how regulatory enforcement and penalties looks like across different frameworks. Impact across sectors. From BFSI sector, financial institutions must implement robust data protection measures as they process sensitive personal and financial data. GDPR enhances trust and compliance but increases operational burdens. In simple language, BFSI sector deals with a lot of personal and sensitive data like names, bank detail, ID numbers, credit score, income, and health data in insurance generally seen. Because of this, GDPR has a big impact on how banks, insurance companies, and financial institutions collect, use, and protect customer data. Key impact on this sector is requiring stronger data protection, which means banks and financial companies must use strong security to protect personal and financial data. They need to keep data safe from leaks, hacking, or misuse. Example, encrypting customer data using multi-factor authentication. The banks or BFSI sector requires more controls for customer. Customers now have the right to know what data is collected. They have the right to ask for access, correction, and deletion. They have right to say no to marketing. They can ask for their data to be sent to another bank. Example, a customer asks to choose their account and request all the data to be deleted, to close their account and request all the data to be deleted. They require clear consent and communication. In BFSI sector, companies must explain why they need your data. They must get clear and specific consent for things like marketing or data sharing. Example, insurance companies must get clear permission before sending promotional emails. Next is policies and records. Financial institution must keep a record of processing activity or ROPA. They need to do data process impact assessment, which is DPIAs, before starting risky projects. Example, a bank launching a new loan app must assess data privacy risk in advance. BFSI sector has a mandatory data breach notification. That is, if there is a data breach, the company must report it to the regulator within 72 hours. They may also need to inform the affected customers. Example, if a hacker accesses credit card data, the bank must notify the data protection authority and affected users. There is also a heavy penalty for non-compliance, which we discussed, at a top 4% of the global turnover if they break the GDPR rule. Example, a global insurance firm that shares customer data without consent can face a huge fine. In summary, GDPR requires BFSI companies to be more secure, transparent, customer focused. It protects customer data and builds trust. But also means BFSI companies must work harder to stay compliant. The next sector is health sector. GDPR mandates strict controls over health data, requiring high standards for consent, access control, and data minimization. In simple terms, the healthcare sector handles very sensitive personal data like medical records, health history, test results, treatments, and insurance information. Because this kind of data is highly private, GDPR has a strong impact on how hospitals, clinics, labs, health insurance companies, and healthcare apps handle personal data. The impact perspective, they require special protection for health data. Health data is considered a special category under GDPR. That means it needs extra protection and can only be used for specific reasons like treating the patient, managing the healthcare system, and for medical research, of course, with safeguards. Example, a hospital can't use your medical data for marketing unless you clearly agreed. This sector has strict consent rules. Healthcare provider must get clear and specific consent to use your data for anything other than treatment. There is a separate consent for things like research, sharing with third parties, or health apps. Example, a clinic needs your clear permission before using your data for medical studies. The next aspect from a healthcare perspective is transparency with patients. Patients have the right to know what health data has been collated or collected. They need to see a copy of their record, which is comes under right of access. They can ask for corrections or even deletion. They can say no to certain type of data use. Example, a patient can ask an hospital to correct a mistake in their medical records. The health sector also requires secure systems and staff awareness. Healthcare system must use strong security like encryption, access control, etc. Only authorized medical staff should access patient data. Staff must be trained on privacy and data protection. Example, a nurse shouldn't be able to access a patient file without proper login and reasons. The sector has strict privacy by design and data impact assessment guidelines. New systems or services like health app must be designed with privacy in mind. Risk assessment, which is the DPIAs, are needed before launching tools that handles sensitive data. Example, a health startup must do a DPIA before launching a symptom checker apps. The health sector also has fast breach notification. If a patient data is leaked or stolen, the healthcare provider must notify the DPA within 72 hours. Inform the patient if there's a risk to their privacy. Example, a hospital must alert patient if their lab results were exposed in a cyber attack. The health sector has high penalties on non-compliance, which is what we discussed, the 4% of the global revenue. That is, if a hospital shares patient data without consent, it could face serious fines and reputational damages. In summary, in healthcare, GDPR ensures that patients' health data stays private and safe, and only necessary data is collected and used. Trust is built with patient and providers. GDPR helps protect your most personal information, which is your health. Now we move to technology sector. Tech companies, particularly social media and cloud provider, have overhauled data practices to ensure transparency and accountability. In simple terms, the technology sector include companies that offer social media platform, search engine, cloud services, mobile apps, e-commerce site, advertising tools, AI and analytics platform. These companies often collect, use, and share a lot of personal data from users, sometimes even across the globe. That's why GDPR has a big impact on how tech companies operate. From an impact perspective, this sector requires more transparency. Tech companies must clearly tell users what data they collect, why they collect it, how long they intend to keep it, who they share it with. An example, a mobile app must show a clear privacy policy before asking for location or contact access. The sector has a strict consent wherein it must be clear and freely given. Users must be able to understand what they are agreeing to, give specific and active consent, and be able to withdraw consent at any time. There is no more pre-ticked box or hidden terms. Example, a website must ask for permission before setting cookies that tracks behaviors. In this sector, users have more control over their data. Under GDPR, user can access their data, correct wrong data, delete their data, transfer the data to other service providers, and also object to profiling or targeted ads. Example, a user can ask a social media platform to delete their account and all related data. This sector has a stronger security measure. Tech companies must use encryption, secure servers, and access control, prevent unauthorized access or leaks, regularly test and update security. Example, cloud service provider must ensure customer data is protected across all devices and servers. The sector has accountability and documentation aspect which needs to be factored in, which is tech companies must keep records of how data is used. They must show proof of compliance with GDPR, called as accountability. Example, a SaaS company must keep a record on processing activities, that is ROPA. If there is a data breach, the company must inform the DPA within 72 hours, inform users if there is a risk to their privacy. Example, if a hacker accesses user password, the platform must notify users quickly. This comes under the fast data breach reporting. From a fine perspective, it's a standard 4% of the global turnover. Example, Google was fined by regulators for unclear consent practice in advertising. In summary, GDPR forces technology companies to be more honest and transparent. Ask for permission before using personal data. Give users controls over their digital privacy. Build systems with security and trust. For tech companies, GDPR is a wake up call to treat privacy as a priority and not an afterthought. Now, coming on to the education sector. Education institute must secure students' record and ensure rights like access and correction are respected. In simple language, school, colleges, universities, and online learning platforms collect and use a lot of personal data about students, parents, teachers, and staffs. This includes names, address, grades, health record, photos, and even online activities. Because of this, education sector must follow GDPR rules to keep their personal data safe and used properly. From an impact perspective, it is protecting student and staff data. Education institute must keep personal data secure, that is with password, encryption, access control, private, only shared with right people, and used only when needed. This is comes under protecting students and staff data category. Example, a student report card should only be shared with students, their parents, and teachers, and not posted publicly. School must explain what data they are collecting, why they need it, how long they will keep it, who it's shared with. Comes under being clear and transparent. Example, a school must tell parents how student photos will be used. Example, for ID card, newsletter, or school website. Consent is required for things that are not essential to education, like publishing photos on social media, sharing student data with third party apps, or service provider. This is about getting consent when needed. Example, parents must give clear permission before a student's photo is used in a brochure. The next is using under GDPR, students and staff have the right to see what data is held about them, correct any wrong data, ask for the data to be deleted, say no to certain uses. This is about giving data rights to students and staffs. Example, a student can request to correct a misspelled name on the school portal. The next is school must keep a record of processing activity or OPA, appoint a DPO, and do data protection impact assessment, which is DPIAs, for new systems or tools. This comes under keeping records and being accountable. An example, a college introducing a new attendee tracking app must assess privacy risk in advance. The next is if a student or a staff data is lost, stolen, or shared by mistake, the school must report it to the DPA in 72 hours, inform the affected people if needed. This comes under reporting data breach quickly. Example, if a teacher's emails a wrong report card to parents, the school must investigate and take action. If an education provider misuses or loses data, it can face warning, fine, and of course, damage to reputation. This is the penalties for breaking the rules. Example, an online learning platform that leaks students' information can be fined under GDPR. In summary, GDPR helps schools and education providers keep personal data safe, be open and respectful with students and parents, build trust in the learning environment. In education, GDPR means putting students' privacy first. Let's look at a summary of over this different sectors. Technology, the data type affected is user profile, tracking data, cloud storage. Main compliance focus is consent management, data transfer, transparency. Common challenges cross-border transfer, AI profiling, consent fatigue. Overall impact high. Frequent data use and global presence is a major challenge. Healthcare, the data type affected are health record, biometric data, genetic information. Common challenges are legacy system, emergency data access, and anonymization. Overall impact is high. Banking and financial, data types is financial data, credit score, account information. Common challenge is complex systems, global operations, vendor management. Impact is very high. Education, it's about student record, academic performance, so on. Major challenge is lack of awareness, consent from minors, system upgrades. Overall impact is moderate, but generally underprepared. Retail and e-commerce, it's about purchase history, payment details, location data. Major challenge is third-party tracker, ad tech compliance, customer opt-out options. Impact is high. Telecommunication, the data types are call logs, messages, SIM user IDs, etc. Common challenge, large user volumes, retention policies, etc. Impact could be between moderate to high. From public sector perspective, the data type could be citizen ID, tax info, social service record. Common challenges, balancing transparency and security, and large scale data storage. Impact high. With this, we have completed part 2. At this point of time, we have covered introduction, origin and evolution of GDPR, scope and applicability, core principles of GDPR, legal basis for processing data, data subject rights, organizational obligations, regulatory enforcement and penalties, and impact across sector. We'll pause here, end part 2, and we'll move to part 3 to cover the rest. While we discuss all the areas, we also discussed the checklist. Do note, the checklists are not comprehensive, it's an indicative list. You can use that as a reference, as a start point, and you can build it, customize it according to your line of business. Look at the full list from GDPR. Interpretation would be required. Bring in your experts, whether it's from your law department, your risk team, your audit team, or any expert in GDPR who can understand what the interpretations are. What I shared is one aspect of it, there could be multiple layers to it. And look at your own business and see how that interpretation looks like. And you can add and build on the checklist. I hope this helps you in some way. Let me just thank you for the time that you have invested for my part 1 and part 2. It's highly respected. So thanking you. This is your host, Savit Vittal Salian. See you in part 3. Namaskar.